Hello, welcome again to the PodCase Podcast, where we answer your questions about personal injury cases. I am your host, Rusty Messer with Big River Trial Attorneys in Baton Rouge. Our co-host today is Maria, our client support specialist. Maria, what question are we answering today?
Why would a case not settle before trial?
That's a very interesting question. Obviously, most personal injury cases settle before they ever get to the court. Something over 90% of civil cases settle through pretrial negotiations or mediation or something else. But there are times when the parties just can't work it out, or for other reasons, the case has to go to trial. So, and there's a few reasons for that. Probably one of the biggest reasons is contested liability. So there's a disagreement between the parties over who's at fault. So let's say we're talking about a car accident case, and so you have two people at a four-way stop sign, right? Both are both traveling through a traffic light, and both drivers are saying, "I had the green light." No, I had the green light. Police officer gets there. He doesn't know. He doesn't find anybody at fault. Doesn't give anybody a ticket. Now you have this contested liability issue. It could be like in a slip and fall case where the person who fell is arguing that the floor was wet, and the business owner is saying, "No, that floor wasn't wet. We had just mopped it, 10 minutes or just cleaned it 10 minutes before that." So contested liability issues are a big reason, especially because Louisiana is what is called a comparative fault state. Now, as we're doing this podcast, there is currently some legislation pending that might change that. Right now, we're a pure comparative fault. That means if you go to trial and you are found 80% at fault for an accident, you can still recover for that other 20% that someone else was at fault. If the bill changes, you would have to be less than 51% at fault to recover. But that hasn't happened yet. That would be another contested liability issue that would force a case to trial. Probably another reason cases don't settle before going to trial comes down to insurance adjusters not recognizing the true value of the case. Look, insurance companies are businesses. The insurance company is not there for you. They are not there to look out for your well being. Their job is to save as much money as possible as they can on every claim. So, some of the tactics they use, they'll make lowball settlement offers. One that we see is very common is that they'll open out of the gate with the medical expenses plus $1,000. I guess some people say yes to that. Another thing that insurance companies will do is they will ignore parts of the damage. They might ignore the pain and suffering and say, "Well, it didn't really hurt that bad." There's this common tactic that I see insurance companies use all the time. So right after the accident, if there's a picture of yourself on social media, doing some activity that you enjoy, the insurance company will say, "Well, you must not have been hurt that bad because look, you were okay." Where conversely, if you have a picture of yourself laying in a hospital bed, they'll say, "Well, the accident wasn't that bad. You must be faking it." So they try to play both sides. Uh, Another thing that insurance adjusters often do is discount the value or the impact of your long-term injuries. So you get in a crash today and or you fall, let's say your back hurts and you do 3 or 4 months of therapy and your back's better, but it may never actually get back to where it was. And so the adjusters will say, like, "Well, look, you've gotten completely better. You don't need any more money. You don't deserve any more compensation." And you're thinking, "Yeah, but now I'm a weather forecaster because every time it gets cold, my back hurts." So that's how the actions of the adjusters will come in and devalue the case.
How do insurance adjusters determine the value of a personal injury claim?
So the insurance adjuster starts off, they will look at the medical expenses, they will look at the medical records. That's why it's very important to make sure that when you see your doctor after the accident, you tell your doctor about the accident. If you had pain that you didn't have before the accident, you need to tell your doctor that so that that makes it into the medical records. Because especially in the initial stage, if we're talking pre-litigation, no one has been deposed, those medical records might be all the adjuster is going. Medical records and whatever your attorney has told that adjuster. So the adjuster looks at the medical bills, looks at the medical records, and they will And they have their formulas. They're each maybe have their own proprietary system, but they will put some value on the case. Then, as the case progresses, the value may change. Typically, once we see a case go from pre-litigation into suit being filed, it actually gets assigned to another adjuster. And I don't know if that's a more experienced adjuster or somebody more trained in litigation type cases, but that alone, moving from one adjuster to the other, can change the value of the case, all in how that adjuster looks at it. And when the adjuster forms their value, they have to go report every so often to their superior. Some have to do what they call a roundtable, where they have to say, look, I have this case, this is the value we have on it, it's not settling. And they may actually have to go ask for more authority from their superiors to try to get that case settled. One of the reasons that your case may go to trial is that there is a dispute over how serious the injuries really are. Uh, Maybe there's a disagreement over how badly someone was hurt. So the insurance company will go find where you went to the doctor 4 years ago because you had some back pain because maybe you were working in the yard. And now they're going to want to say, oh, well, all your back pain happened 4 years ago. It didn't happen in this crash that you were in, you know, 4 months ago. Uh, and of course, that's just not common sense, but that's a game that insurance companies play where they're looking for everything they can to push off the severity of your injury. So they might claim it's a pre-existing injury. They might question whether or not you need certain medical treatments you're going to need in the future, and they just don't want to come up with the money to pay for it. So the only way you're going to get that paid for is taking your case to trial. They will also argue that, look, if you recovered quickly, you don't really deserve any compensation. Look how quickly you recovered. Guess what? Some people are tough. Some people push through. That doesn't mean they didn't have real pain just because they went on with their life. And look, some common injuries are not readily visible. You talk about somebody having a concussion, maybe back injuries, maybe even a knee injury or something like that. That's not a broken bone, right? A broken bone is easy to see, but that doesn't mean those are not real injuries. So you may have to bring your case to trial to get the true value of that injury that the insurance company is undervalued. Uh, Another reason is a lack of witnesses or a lack of evidence. And this is a little bit like our first reason, where we talked about maybe a he said, she said situation. But maybe you have something where there are no witnesses, there's no physical evidence, there's no video. We've gotten much more technological on all of that stuff. So there's a lot more camera. I mean, if you're driving certain type of cars, they have cameras built in. But let's say you don't have any, or or you have conflicting evidence. Let's say that there's evidence that one person pulled out in front of somebody and somebody else is saying, no, that person didn't pull out in front of that person. Maybe that's a independent witness on the side. So that conflicting evidence might keep the case from settling, and you have to go put it in front of a jury. Because when you bring your case to trial, that is what happens. It's a jury, or in some cases a judge, but in most cases a jury who hears your case and decides who was really at fault and how much the case is worth. Uh, Probably another thing that keeps cases from settling are unreasonable defendants. And so this can be like the insurance adjuster, but it can also be the actual defendant. Maybe the other driver is just adamant that they didn't do anything wrong and they will not allow their insurance company to settle. And they want to go to trial to have their day. This happens a lot when you have a corporate defendant. So let's say it was a company and one of their drivers caused an accident and the driver's telling them, I didn't do anything wrong. Well, that company might dig in and refuse to pay anything. Now you have to go to trial. It could also come up that it's a high stakes case, right? So if there's a potentially large jury verdict that might come out of this, a lot of times the defendants or the insurance companies, they are just dragging the case out because if they have to pay, they would rather do it later rather than sooner. And sometimes pushing your case to trial is the only way to get them to pay.
Are there valid reasons to take your case to trial instead of settling?
There actually are. Uh, One good reason to take your case to trial. I mean, of course, we talked about the low offers and things like that, but going to trial is where you're going to have the chance, the opportunity to get the highest award. Because at that point, the award is in the hands of a jury not an adjuster or not some defendant. Uh, Now, that doesn't mean you will always get the highest award. The jury may not give you that highest award, but that is going to be your best chance to get the highest recovery. Uh, Going to trial also has some effects of holding people accountable. When your case settles, there is no apology. There is no one who says a finding that anybody did anything wrong. In fact, that's always in the settlement agreement that nobody's admitting liability, just settle. But when your case goes to trial, that other person, that defendant has to get on the stand and they have to defend their action. And if they really don't have a defense to it, the jury's going to see through that. And a reason that we're always pushing our cases for trial is that just pushing your case to trial increases the value because the insurance companies and the defendants know that your best chance at getting the most money comes from going to trial, comes from asking that jury for that money. Pushing your case to trial helps it settle, and that's why we see so many cases that settle kind of right on the courthouse step. Lots of people come in and they're very concerned about their case going to trial. When is it going to go to trial? How long is it going to take? A long time to get your case to trial, unfortunately, just because the courts are backed up and there's discovery and other issues. But it's something that I've been asked a lot by people coming in is my case going to go to trial? Is it going to settle? And we start every case with the outlook that it is going to go to trial. That doesn't mean we go to trial in every case, but that's how we start because we believe that's how we get the best results. All right. So I want to thank you all for watching today. The replay of today's podcast will be available on our YouTube channel. It will be on Spotify, wherever you enjoy your podcast. If you have a question that did not get answered, please make sure to email us at podcase@bigriverlaw.com. If you enjoyed this episode, make sure to like and subscribe.